I can waive his appearance for the anticipated dismissal.
Okay, on the record, in the matter of the state of Michigan versus John Mayberry, 2P-03040, appearance, please.
Good afternoon, Your Honor. Matt Nagel for the people.
And good afternoon, Your Honor. Jared Austin appearing on behalf of Mr. Mayberry. He's present in the building. He is down in the lockup. I will waive his appearance for the purpose of this anticipated dismissal.
Thank you. Today was the date that was scheduled for preliminary examination for assault with intent to great bodily harm, NIDV. And my understanding is we do not have the necessary witnesses.
That's correct, Your Honor, and therefore people are unable to proceed. And due to that, I would expect defense to make a motion.
Yes, Your Honor. Given that, I would ask the court to dismiss the case against Mr. Mayberry, understanding, of course, that the dismissal is without prejudice.
Thank you. We'll grant the dismissal without prejudice and we'll give you a copy so that you can advise your client. Any additional matters for the record?
Not for this part. Thank you, Your Honor.
I have nothing on behalf of Mr. Mayberry, Your Honor, and I will later inform him of the dismissal. Thank you.
Thank you. You're all set. This is the matter of the people of the state of Michigan versus Derek Parker, 24-03566FY. Appearance, please.
Good afternoon, Your Honor. Matt Nagel for the people.
Public Defender Sarah Donnelly on behalf of Defendant Derek Parker, who is standing to my right.
Today was the date scheduled for a preliminary examination for interference with electronic communication. There was a count of BV to accompany. How are we proceeding today?
Your Honor, necessary witnesses on it is not present this morning.
Your Honor, I'd ask if the case could, well, the entirety of its case could be dismissed without prejudice at this time.
Motion dismissed is granted without prejudice. We'll get you a copy of the dismissal. The people do have the right to reissue this charge against you. Do you understand that? The people have the right to reissue this charge against you. It's being dismissed without prejudice. Do you understand that?
Yeah. Yes, Your Honor.
Thank you, Your Honor.
No question?
No.
Okay, we'll get you a copy of the dismissal. Any additional matters for the record, counsel?
Not for the people. Thank you.
Not from dispense, thank you.
You're welcome. What are you ready for next?
Your Honor, we still have a couple things on the 1:30 docket, but if it pleases the court, I think we are good to go at this time on Mr. Carter. It'll be a same.
I did see Mr. Palmer here. Is he behind my computer at all?
Oh, yes, ma'am.
Oh, okay.
Hiding.
I can't see that yet.
Yes, ma'am. I'm ready to go whenever, but I think.
We're running that one. Is that what's going on?
I think so, Your Honor.
Okay.
That's what it sounds like.
Yeah.
And then you said who, Holly for sentencing?
No, Mr. Carter.
Carter.
Yes, Your Honor.
What are we doing on Carter?
That's going to be a dismissal. We've not been able to get in touch with the complaining witness in that case. I don't anticipate.
On the record in the matter of the state of Michigan versus Marcel Anthony Carter, 24-03251. Appearance.
Good afternoon, Your Honor. Matt Nagel for the people.
And Luke Goodrich from the Public Defender's Office, here to represent Mr. Carter, who's standing to my right.
Okay, Mr. Carter was scheduled for a preliminary examination of child abuse code and NDOP domestic, and then a domestic violence that accompanied, and we do not have the necessary witnesses. Is that correct?
That's correct, Your Honor. We've been unable to get in touch with them. I don't have a time frame as to when that might occur. So therefore, people are unable to proceed today, and based on that, I would expect defense to make a motion.
Would that be the case, Your Honor? The defense has moved to have this matter dismissed.
Matter is dismissed without prejudice, so that means that they do have the right to reissue this against you. Do you understand that, sir? Get your copy of the dismissal in just a moment. Any additional matters for the record, counsel?
No, Your Honor. Thank you.
Your Honor, I just point out that there is still a no contact order in place based on a misdemeanor file between these parties that is still ongoing.
Just remind Mr. Carter that case still remains as of now.
Thank you.
Your Honor, I believe. So I think Joe Dersma is going to run. I need to check the hallway one more time regarding a witness on Mr. Smith.
Okay,
Um,
is the attorney on that here?
the attorney is here on that. I think he's out in the hallway. I need to double check on the witness. I haven't seen her yet, but I don't have a reason to think she's not.
Sounds good. And, Mr. Austin has a sentencing. That,
On Mr. Holly, it's also set for the PA.
oh, is there a hearing on that? What are we doing on the paper? He's here, let's see here.
So I've got an officer who's available. He texted me at 2:03 saying that he'd be here in 10 minutes. So,
Oh, he's not here yet. Okay.
well, I want to check.
Got it.
He might be.
I was gonna bring, Holly up, but if we're not ready yet, I won't bring him up.
Well, it indicated he would be admitting to it.
Okay, she can bring him up then while you go check for your witnesses.
Thank you.
Can you have Holly brought up, please?
Oh, he indicated that the last time, and changed his mind.
It happens.
Yeah.
Yep, then he told me what he
We
did.
shall see.
Okay, and so you understand that you have been accused of violating your bond conditions while in the custody of Ingham County Jail. There is allegations of violating the no contact order on multiple occasions. Primarily across, it looks like,
There should be just one, Your Honor.
the messages from August, I'm sorry, from who's in jail, messages from, it says October 17th and October 15th.
Well,
And then there were, it looks like messages from the 8th of January.
may I,
And then January 4th is what it says here.
well, hold on, Mr. Holly, let me speak, please. The way I understand it in the report, Your Honor, is that it stated that it appeared that the protected party had reached out to Mr. Holly while he was in custody, but it appeared he had not responded in kind to those. So I don't think that would be a violation. But this violation that we are here on is that he sent a message, a text message to the protected party.
On the 4th of January, 2025.
Yes.
And then it says here on January 8th, 2025, Holly sent messages. So it's 2 dates. Okay, actually, I think the 4th might be message to someone named Carl Morrison. Not the protected party.
That is correct. Your Honor.
Okay, sounds good. So you want to plead guilty to sending that message, correct? Do you understand the words that are coming out of my mouth?
Yeah.
So what does that signal that you just did with your face and head, what does that mean to me?
Yeah.
Well, then use your words. I'm using words for a reason. Do you know what the reason is? The court recorder has to take down everything stated in the court. And take down whatever you did with your head. Okay, so are you pleading guilty to the violation that you sent message to the protected party back on January 8th, 2025?
Yeah.
Okay, anybody threatening you to do that?
No.
Any promises being made if you plead guilty to that? Okay. You were on bond before this court for a pending matter, is that correct? Well, you have a bond that's issued or under a bond order. Was there a no contact order that was in place at the time of January 8th, 2025 because of a pending case? Was there a no contact order?
I don't remember. All I know is I don't want to plead guilty to it.
You don't remember what? You don't remember being arraigned and being told that you couldn't have contact directly or indirectly with Jessica Redmond? No, you don't remember that?
I just pleaded guilty.
Answer my question.
There wasn't no bond.
No, my question was, do you recall a no contact order? Saying that you can't have contact directly or indirectly with Jessica Redmond during the pendency of this case.
This is so funny.
Answer my question.
Yeah.
And did you violate that order?
Mhm.
Is that a yes?
Yeah.
Okay. Any other factual basis?
I'm satisfied, Your Honor.
The people are too young.
I'll accept your plea or find your plea to be made freely, voluntarily, and intelligently. You also need to be sentenced on the underlying case. You can address the court on his sentencing.
Yes, thank you, Your Honor. Your Honor, Mr. Holly admitted guilt to a 1-year misdemeanor. He has served well over half of that. He has nearly 7.5 months of credit on that case. He is technically on probation to the circuit court, although I don't think he's ever really gotten a chance to start that supervision, as he's been in custody since almost the entire time. He does have 2 pending matters still in circuit court, one with the same party involving this case, and I don't think those are likely to resolve anytime in the near future. So I don't think it would make much sense to place Mr. Holly on probation here. What I would ask the court to do is sentence him to the time that he's already served, which is 220 days of credit.
As to the underlying matter, I have a report from pre-sentence report from our probation department that is similar to what you said. He's not a candidate for probation. It says that he would be inappropriate to be placed on probation. He's being held on 2 pending cases. And that he seems to minimize his actions and not take responsibility for them at all. And that he indicated that he didn't put his hands on the victim, but he did in the past, but not on the date alleged, and that he only pled guilty because he thought that was the best thing to do. His interaction with the probation officer was marked as troubling or concerning. It says additionally, the defendant's criminal history is extensive, and he has 3 other pending cases currently on top of this matter. He is for a currently pending robbery case, as well as an assault and murder in the 30th Circuit Court, and some prior convictions from 2015, 2019, and 2023. He'll get credit time served for this matter. As to the violation, 93 days Ingham County Jail that will be served consecutively to this sentence. Any additional matters for the record?
No, Your Honor, thank you.
Any additional matters?
I have nothing additional to add, Mr. Hollier.
He's all
Thank you.
set.
Your Honor, when the court is ready, I think we're ready to proceed on Mr. Roman Smith. Mr. Roman Smith.
This is Mr. Smith, correct?
That is correct.
On the record in the matter of the state of Michigan versus Roman Smith 24-03483, council appearance.
Good afternoon, Your Honor. Matt Nagel for the people.
Good afternoon, Your Honor. Robert Henry Joseph here on behalf of Mr. Smith, who joins me to my right.
Okay, today's the date that was scheduled for a a preliminary examination. And this is for controlled substance possession of methamphetamine ecstasy and aggravated indecent exposure. Proceeding today.
Your Honor, the people are going to be requesting an adjournment. However, the reason we're going to be requesting an adjournment is because the victim on the aggravated indecent exposure has called the police twice on this defendant, and so the cooperation in this matter by the victim is expected. However, I'm not sure if there was a breakdown in the sending of the subpoena. So I would request an adjournment to give you an opportunity to get in touch with the victim to make sure that she has enough notice to come back to the court. If this is dismissed today, I advise counsel that we are certainly going to reissue. So rather than go through all of that, that's the purpose for the request of adjournment. The same goes for the police officer, Your Honor. I don't know why the police officer is not present for count one. I would ask for adjournment for that same reason. All this to say as well, because the responsibility is on the people to ensure that the subpoenas are served and witnesses are present. I don't think this qualifies as good cause. I'm merely just asking the court's consideration, given the fact that if this is dismissed, we would be seeking to reissue. All of that said, I do expect defense probably to make a motion to the court based on our inability to proceed today.
Well, I don't need to make a good cause determination on this, at least for the timeline, because we've already done that. December 13th, defendant requested, or we had defined good cause so that he can retain counsel. Then it was set for another date that the defendant failed to appear on. I don't need to address any timelines. However, counsel, I'll let you respond.
Thank you, Your Honor. At this time, I'd move for dismissal. This was the date and time set upon Mr. Smith retaining me. If the people are unable to proceed at this point, I'd ask that the matter be dismissed.
Okay, well, the people have indicated that their intention is to reissue this. That's correct.
That is correct, Joe.
Well, it's not in the interest of judicial economy to dismiss it, just for them to reissue it, for us to get you back to Ingham County, and then we have to get you back here to be arraigned all over again. Because they'll have that paperwork done likely before you can get released from custody. So I'm gonna grant the request for an adjournment, also recognizing that there's been an adjournment on this more than one occasion, attributed to the defense and not to prosecution. So I will go ahead and reset this for another exam to allow time for proper subpoena. March 13th at 9. March 13th at 9 a.m. Does that work for you, counsel?
It does, Your Honor.
Okay.
You know why we're on the record, may we address bond?
You may.
Thank you, Your Honor. Mr. Smith is currently being held with no bond due to actions of his own. However, I'd ask the court consider setting a reasonable bond in the matter so that he may have an opportunity for exactly that.
Why didn't you come to court?
I had mixed my dates up. I put the wrong date in the calendar. I put the previous date in instead of, I put the 6th instead of the 3rd. So I intended to come to court that day, but I just mixed my dates up.
Okay, so when you were arraigned on the warrant on the 5th, how did you did you turn yourself in on that date?
I did not. I called my lawyer and I wasn't sure what to do.
How did you get arraigned on the bench warrant? You didn't turn yourself in, or were you picked up on another matter?
I'd gotten pulled over with a friend of mine and they picked me up.
Oh, okay. Your address?
3590 Vandecar Road. Possible.
I think bond was previously 2,000 personal recognizance. I'll reinstate bond at 2,000 personal recognizance. You need to report to your court date, okay?
Yes, Your Honor.
Thank you, Your Honor.
All other bond conditions that were previously provided at the time of your arraignment will continue. Any additional matters for the record?
No, Your Honor, thank you very much.
No, Your Honor, thank you.
We're all set.
So, okay, so Your Honor, I think we're ready on Miss Larkin. That's going to be a plea, and then I know Yolanda's busy. I think we'll probably be able to roll right into Jill Dojma when the court is ready after that.
You know something? He's moved to full.
You say you want to adjourn?
Yeah.
Okay.
From the gulag.
Oh, they're gonna come in?
Yeah, they don't get the thing.
Sounds good.
Your Honor, would it be okay if I took 30 seconds? Just to- I think we're ready for Ms. Baker. Or Larkin, sorry.
On the record in the matter of the state of Michigan versus Ayana Larkin, 23-03218. Appearance, please.
Good afternoon, Your Honor. Matt Nagel for the people.
Good afternoon, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Ms. Larkin, who is present and now stands to my right.
Okay, today was the date Ms. Larkin was scheduled for an exam as police officer Plea. How are we proceeding on this?
Your Honor, the people have been in communication with defense attorney on this matter. We have offered to amend this from a fleeing and elude fourth under the vehicle code to an attempted flee and elude fourth under the penal code. And with that, we've consented to a petition sentencing under HIDA. That does not a kilobrew. That is the consent, and I think that's the
Yes.
entirety of the offer, and
Yes.
it's my understanding that the defense is going to take that offer.
That is correct, Your Honor. If I may approach with
Yes.
Vice Regs and such. Grab the space.
Thank you. And Ms. Larkin, you want to accept the offer to plead guilty to the amended count one fleeing or attempted fleeing and eluding fourth under 750.179A2A. Is that correct?
Yes, ma'am.
Okay, and that's a misdemeanor with a maximum penalty 1 year and or $1,000 and 6 points and 1 year suspension. And there's no objection to sentencing under HYTA. You understand that? Okay, raise your right. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury. You can put your hand down. I have an advice of rights and plea information sheet here. And it has your signature. Did you read this document? You understand the rights here? Are these rights that you're willing to give up today in order to accept the offer to plead guilty to the amended count?
Yes.
So that means that you're going to give up and waive your right to be presumed innocent until proven guilty. You are innocent until proven guilty, and you have the right to require the prosecutor prove your guilt by proceeding to jury trial, at which time they would have to prove each element of the charge beyond a reasonable doubt. You understand that? Is that a yes?
Yes.
Okay, you would have the right to remain silent at any trial and not have that silence be used against you, or you can waive your silence and testify at your trial if you like. You also have the right to have witnesses subpoenaed to testify at your trial on your behalf or present evidence that you believe show a defense to the charge being brought against you. And you also have the right to see, hear, or question any other witnesses that the prosecutor intends to call to testify against you. You understand each of those rights?
Yes, ma'am.
Is anyone threatening you to get you to give these rights up?
No, ma'am.
Has there been any promises and enticing you to give up your rights?
No.
Are you currently on probation or on parole?
No.
You understand that a guilty plea could result in a conviction that may have impact on travel or immigration status that you may be seeking.
Yes.
It also could become a conviction that you may need to report to your current employer or report it to a future employer.
Yes.
As to the amended count one of attempted fleeing and eluding force, do you plead guilty, not guilty, or stand mute?
I plead guilty to that.
Is that because you believe you're guilty?
Yeah.
Factual basis, counsel.
Thank you, Your Honor. Ms. Larkin, back on June 8th of 2023, were you at or near a location of South Martin Luther King Jr. Boulevard and William Street?
Correct.
All right, and that is in the city of Lansing County, Bingham, state of Michigan?
Yes.
And at that time, you were pulled over, and I believe the reason for it was for, to my knowledge and to yours, was for speeding. Would that be correct?
Yes.
And that was by an officer, a Lansing Police Department officer. Would that be correct?
Yes.
He was on a motorcycle at that time. Is that also correct?
Yes, ma'am.
And you knew you were being pulled over,
Yes.
and his vehicle, you knew it was a police officer. The vehicle was clearly marked in his uniform, such.
Correct.
All right. And as he approached you, you ended up driving away. Is that correct? Okay.
That is correct.
And you did that with the intent of getting away from being pulled over.
Yes, ma'am.
All right. So And I understand. And this was a road that was open to the public, generally accessible, that kind of thing.
Yes.
All right. And do you have any reason to doubt the reason for why the officer was initially interacting with you or trying to?
No, I was in the wrong that day. Honestly, there's no explanation I can further say that day.
I got you.
So, yeah.
All right. So if the court or the prosecutor has any further questions, I will also note, I'm trying to do the math here very quickly. The date of this offense being 6/8/2023, and I believe her date of birth is 6/20/2001. So math is not my, okay, she was 21 on the date of this offense, never mind. All right, so we do need the consent of the prosecutor, which is my understanding that has been given at this time for the seeking of HYTA status. Thank you.
Thank you. The court is satisfied with the factual basis of accept your plea and find your plea to be freely, voluntarily, and intelligently given. On the matter is set for sentencing March 27th at 9 a.m. When you leave here, you'll go down one floor to our probation department and check in with them so they can get you set up for a pre-sentence interview. So they can give me a report as to how they believe you are to be sentenced and if you're even eligible for sentencing under HYTA, okay?
Yes,
Okay. You can appear for your sentencing via Zoom. Do you have any questions?
no, ma'am. You said I'm sorry. You said I could this
You-
time on Zoom?
For Zoom, yes, you can.
Okay.
You just need to have a video, okay?
Okay.
Okay, any additional matters for the record?
No, Your Honor, thank you.
Just one thing briefly, Your Honor. I want to make sure I make a record of this. Ms. Larkin, we discussed any impact on driver's license, the potential sanctions that this will impact, very likely will impact your driver's license. Is that correct?
Yes, ma'am.
And you didn't have any questions after we had that conversation?
No.
And you understand that this will very likely suspend your license?
Yes.
Okay, thank you. Nothing further, Your Honor. I
Thank
appreciate
you.
it.
For the record, I read that sentence into the record.
I
That's a better way.
apologize, Your Honor. I apologize. Your
Thank
Honor.
you. You're all set.
Thank
All
you.
right. Thank you so much.
On the record in the matter of the state of Michigan versus Gregory Abraham, I have file number 12-03-377. And then I have file number 12-05-335. Council appearance.
Good morning, or wow, good afternoon, Your Honor. Michael Anderson on behalf of Mr. Abraham, who does appear personally to my left.
Actually, this is city of Norwalk. Versus Abraham. Okay. I had to stop and look because I was that city attorney's office for this issue. Okay, let's see. This is old. I have a open alcohol in public citation that it looks like you were previously arraigned on. You were supposed to appear. Looks like August 15, 2012, but failed to appear. Now, assigned to me, let's see. The citation alleges that on or about July 25th, 2012, at approximately 12:40, that you were at the area at or near 400 South Capitol, at or near Ruger Park, and that you allegedly had open alcohol in public. It states in the remarks, had a 24-ounce can of Labatt blue beer sitting at park. Let's see. I'm trying to see if I can see the officer's name, but I can't understand their handwriting. Nonetheless, you have the right in this matter to a trial. You have the right to a jury trial on that matter. It's a misdemeanor with the maximum penalty of 90 days and or $500 in fines. And then I also have here a misdemeanor warrant. It alleges that on or about July 24, 2012, at the area of 500 East Michigan at or near 300 South Capitol, that you allegedly in count one committed the act of stolen property, receiving, concealing less than 200, and that you did buy, receive, possess, conceal, or aid in the concealment of a Garmin GPS and or a Sirius XM interface stolen, did buy, receive, possess, or conceal those things, or embezzled or converted property, knowing or having reason to know that the property was stolen, embezzled, or converted, and the value of the property was less than $200, contrary to MCL 750.5355. And so count one is a misdemeanor. Maximum penalty is 93 days and or $500 in fines, and 3 times the value of the property, whichever is greater. Count two, stolen property, receiving and concealing less than 200. Allegations are that you did buy, receive, possess, conceal, or aid in the concealment of a Garmin GPS, stolen property, a converted property, knowing or having reason to know or believe that the property was stolen, embezzled, or converted, and the value of the property was less than 200, contrary to MCL 750.5355. And so that's a misdemeanor with the maximum penalty 93 days and or $500, or 3 times the value, whichever is greater. So you have the right in that matter as well to a trial and a jury trial. You have the right to be presumed innocent until proven guilty, and to require in this matter the prosecution to prove each element of the charge or charges being brought against you beyond a reasonable doubt. In each trial, you have the right to remain silent at any trial and not have that silence be used against you. You can waive your silence and testify if you'd like, or you can have witnesses subpoenaed to testify on your behalf. You have the right to present evidence that you believe show a defense to these charges, and the right to see, hear, or question any other witnesses that the prosecutor or the city calls to testify against you in these files. Do you understand those rights?
Yes, ma'am.
And so is entering a not guilty plea today.
Yes, sir.
Are these both assigned to me? Yes. Looks like in the file number 12-03377, you're scheduled for a pretrial conference before me, Judge Simmons, Monday, February 24th at 10 a.m. And then the other file. Did I say the wrong number? Okay, I think I said the wrong case number. 12-05335. Which is the state case, is scheduled for Monday of the 24th. The city case is scheduled for Tuesday, the 25th at 10:30. Both for pretrials. And I think that this is the attorney's copy. It's the defendant's copy. Copy of his prior criminal history. I don't see any convictions or interaction with the criminal justice system since 2007.
You said you like this.
I have it, thank you. Bond and 12-05335 is $500 personal recognizance allowed out on bond. You're not to leave this, well, you live outside the state, is that correct?
Correct.
Where do you live?
Florida.
What's your address?
7514 Marks, MARX Drive. North Fort Myers, Florida. 33917.
What's your phone number?
239-218-2386.
Let's see, you're not to engage in any assaultive or threatening behavior. Not to use drugs or alcohol. Without a prescription during the pendency of this matter. And you're not to possess a firearm or any other dangerous weapon. And the open alcohol, your bond is 100 personal recognizance. Same conditions will apply as to that. You can report to all of your court dates via Zoom. And let's see. I'm just trying to see who the- victim on that one would be, but I'll leave that to the prosecutor, because I would have moved to a final pretrial. Got it, okay, I'll leave that to them, they can figure out what they wanna do. Okay. Your notice, oh, we've given you your notice on those ones. Do you have any questions for the court at this time?
No, ma'am.
So do you have any other matters for the record?
No, Judge, thank you.
You're all set.
Nice to meet you. Yeah. I'm sure you've done this. Present.
Are we up next?
We should be, I don't think there's anything else, so.
There's nothing else coming up.
All right, thank you, Judge.
1 through 5, top down.
Okay.
Thank you. Over texting me, he just pulled up. He's sick. He thinks it's not dangerous, so.
Sick, you think?
One of the officers is about to
Yeah.
testify.
And he can't come in here. You ready to read the case? Yeah. On the record in the matter of the state of Michigan versus John Paul Jurma, 24-03259. Okay, council appearance.
Good afternoon, Your Honor. Matt Nagel for the people.
Good afternoon, Your Honor. Robert Palmer, the Public Defender's Office, on behalf of Mr. Childers, who's standing in front of it.
Is he a rainbow? Yeah. Okay, sounds good. Today was scheduled for a preliminary examination and a hearing, I guess. A bond violation, is this currently in Wednesday?
Yeah, I was confused about that. I didn't know if it was supposed. I think that's
It shouldn't be
whatever the
warranted.
whatever the violation was, but I don't know if.
This is the violation, but it's date stamped for the 3rd. I see on the 4th. I wrote revoke bond and remand on bond violation. I don't see that he was arraigned. Have you been meeting with pretrial services?
Yes, Your Honor. I've been in contact on the phone.
Since when?
I just talked to her 2 days ago.
I think that was why I revoked it, because they notified us of a long history of them trying to make contact with you without any attempts or any contact back.
Judge, for what it's worth, I'm not sure what's going on there. I can, as offer proof, the court wants to see it. Mr. Childers has tried to reach out to them numerous times. In fact, for example, on the violation that's scheduled for today, one of the violations reads, on November 19th, reporting investigator received an email from the defendant asking about his next scheduled check-in. Reporting investigator did not see it until because it went into the spam junk folder, except then they're saying that he didn't check in on the 20th. I have a copy of the email where Mr. Childers emailed her on the 19th saying, I'm just confirming my appointment is with you tomorrow, correct?
You don't need the email because they said in there that emails, they already know.
Well, right, I guess what
You
I'm,
mean your client shouldn't be responsible for going to the spam folder?
that's kind of what I'm saying.
Oh, okay.
That's part of what I'm saying. And also, I guess I'm trying to point out that there was some confusion, I think, on my client's behalf about when his next check-in date was. He didn't want to miss it. He's making attempts to verify with pretrial services, hey, I'm supposed to check in with you tomorrow, right? Then he never hears anything back from pretrial services. And then a couple of days after that, they say, oh, well, we found this email after the fact, but he missed the date that apparently he was asking about. And, and so now we're going to issue a violation for the fact that he missed the date that he asked to confirm that they never responded to him about.
They did respond on the 2nd.
On the 2nd, after he had already missed the date.
It was in the spam folder.
You're right, Judge, it was in the spam folder, and I have issues with that, is what I'm saying. And my
I do too.
And my
It's dismissed.
Thank you.
Thank you.
And as Mr. Childers said, my understanding is that he's been talking to them since then. He's not missed any other check-ins, anything like that. So I think everything's on board.
Sounds good.
Thank you.
Okay, but we're ready on the underlying matter?
We are, Your Honor. The only preliminary matter that people have, I've got 5 proposed exhibits. I have showed them to the defense. I don't think there's any stipulations.
No, I suspect they'll come in. So I'm aware of what all of them are. My only preliminary matter, it's already happened, but I would ask for sequestration of witnesses. I think there's 2 witnesses to testify to.
I'll make sure
Officers?
that's correct, Your Honor.
Okay, sounds good. Sequestration is granted.
What happened to the officer? That's what. Is the officer coming?
Oh, yes, no, we're ready, Your Honor.
He was just gonna call you witness.
Okay, thank you, Your Honor. People will call Damon, Officer Damon Vogel.
You solemnly swear or affirm the information you're gonna provide is true to the best of your knowledge, information, or belief.
Yes, Your Honor.
You can have a seat. State your first and last name and spell both.
Damon Pulver, DAMONPULVER.
You can proceed, counsel.
Thank you, Your Honor. Officer Pulver, with whom are you currently employed?
I'm currently employed with the Lansing Police Department.
What do you do for Lansing Police Department?
I'm a police officer.
What are some of your responsibilities as a police officer with LPD?
My responsibilities as a police officer are to respond to calls for service and to do patrols throughout neighborhoods.
Right, and I assume part of those is to investigate crimes as you arrive on scene.
Yes,
Answer calls. Okay. How long have you been a police officer?
I've been a police officer for a little over 4 years.
And were you working in this capacity on October 26th of 2024?
Yes, I was.
Do you recall making a traffic stop in the vicinity of 517 Regent Street on October 26th?
I do.
And was that location in Lansing, County of Hingham?
Yes,
Do you recall whether or not that traffic stop turned into a narcotics investigation?
I did. I did.
Have you conducted narcotics investigations before?
I have.
Are you able to give us a best guess as to how many narcotics investigations you've conducted?
If I were to guess today, I would say around 50.
Okay.
Somewhere there.
Did you have to attend any special training in order to do this?
Not specifically for that, but I have done like A-ride training, which gives additional training on how to recognize drugs or someone under the influence of them.
Okay, and you participated in that training?
I did, yes.
And did that training result in a certificate or diploma of some sort?
It did.
And did you earn that certificate?
I did.
Did you participate in any other additional training or anything with respect to investigating narcotics?
No.
Can you tell the court what you remember about that traffic stop on October 26th?
Yes, I remember doing a traffic stop and the car had pulled into the driveway of 517 Regent. When I walked into the car, I noticed that it was occupied by 2 people, a driver and a passenger.
Okay, I'm going to back up for just a moment. Did you conduct a traffic stop on that vehicle?
Yes, I did.
What was the reason for that traffic?
The reason for the traffic stop was for the window tint on the car, on the front windows, and then also for them having a high beam on.
What was important about the high beam? What did that signal to you?
So for me, it was late at night. I was in the intersection and they were driving opposite of me, and it was kind of blinding where I wasn't able to see very well while approaching an intersection. So for me, it was kind of more of a public safety issue for being that late at night.
Okay, and in addition to that, you said something about the front window tints.
Yes.
What about that?
So I could see that there was very heavy window tint on the front windows of the car, which made it very difficult to see inside the car or the people wearing their seatbelts or what was going on inside the car.
And the window tints on the front window, is that allowed under Michigan law?
No.
So the basis for your traffic stop here was it an equipment safety issue? Is that what was going on?
Yes, that and the high beams, yeah, but mainly, yeah.
So that and the high beams.
Yeah.
So what happened when after you made a traffic stop?
when I did the traffic stop, I walked up to the driver's side and identified myself as the driver and identified him.
And were you able to identify the driver?
Yes,
How were you able to confirm his identity?
through either gave me an ID or I went back and I confirmed it through the Secretary of State on my computer, through an SOS photo.
Through an SOS photo?
Yes,
Would you recognize that person if you saw him again today?
yes,
Did you see him in the courtroom?
I did.
Can you point to him and identify an article of clothing that he's wearing?
There's Mr. Dodersma with the nice sweater on, no button up underneath.
Thank you, officer. Your Honor, may the record reflect that.
Any objection?
Not for example.
Identifications noted.
Thank you, Your Honor. Once you made recognition of the ID, what were you able to determine anything about that vehicle that was relevant to this traffic stop?
Yes, so when I went back to my car, I had ran Mr. Dodersma and the law enforcement information system, and I also ran the vehicle in the law enforcement information system. The vehicle had came back with no insurance on it, and Mr. Dodersma came back with no valid license. It was actually revoked.
Okay. When you ran the registration, were you able to determine who owned the vehicle?
I don't recall.
So since there was no insurance on the vehicle, and because Mr. Joel Dersman did not have a valid driver's license, what were you required to do next?
So I was required to try to find some sort of solution to the vehicle. We were able to get the information for the passenger who did not have a valid driver's license at the time. So with no one being able to drive the car, with no insurance being on it, we decided to tow the vehicle.
Before you tow the vehicle, what do you do with the vehicle?
Before we tow it, we conduct an inventory search of the car.
And what's the reason for that?
The reason for that is to account for any sort of valuable belongings that might be in the car prior to a tow truck taking off with it.
Did you conduct an inventory search on this vehicle?
I did.
Did you find anything of evidentiary value?
I did.
Let's back up for just a moment and talk about some of these narcotics investigations.
Yes.
Do some of these narcotics investigations involve possession of a type of narcotic?
Yes.
And did you also investigate, of these 50 that you told us about, did you also investigate crimes that included possession with intent to distribute narcotics?
Yes.
Can you explain to the court what you look for to distinguish mere possession from possession with intent to deliver?
Yeah, so the mere difference depends on a lot of different factors. A big one is going to be the quantity of the narcotic that is involved with it. Typically, in my experience as a police officer, someone that is just merely in possession of a narcotic that is just for use is usually around a gram of some sort of narcotic that they typically have.
Joe, I'm just going to object to relevance at this point. He's not been qualified as an expert. He can testify to what he found on this particular case, but what the other cases he's experienced, I don't know what the relevance is to that. He's not an expert, so he can't offer testimony.
What's the relevance of this line of questioning?
The relevance of the line of questioning, Your Honor, is to, I mean, I don't know if I need to qualify him as an expert, but based on his experience and training, I can establish an expertise in certain kinds of investigations with the narcotics. Specifically, what I'm getting at is, which we haven't gotten to yet, but once I ask about what was found in the vehicle, I'm trying to create the foundations for relevance regarding how it's connected to a intent to distribute as opposed to, what the defendant may have, but merely for personal consumption. There is a difference that the officer was discussing. I wanted to set the foundation for what officers look for, and then based on that foundation, once we talk about what was found in the vehicle, that would allow the court to make a reasonable inference as to whether this was a mere possession or possession with intent to distribute. Did I make that as clear as mine?
I understand where you're going. I don't think you need to go into too much detail about his background for that purpose, though.
Okay, fair enough. All right, thank you. All right, so let's just get into then what you found in the vehicle. Do you recall?
Yes, so right around as I just started my inventory search, I located 2 baggies of suspected narcotics that were underneath the seat right at the floorboard of where the driver's seat area was at. So after locating that, I believe that it looked like methamphetamine. So we went and detained Mr. Deverswa. Excuse me. And then I continue to search through the vehicle now with as both an inventory search and as a probable cause search both for additional narcotics.
So to be clear, you said you found 2 bags?
Yes.
You said it's suspected methamphetamine. At this point, you didn't know what it was, correct?
Right. I was not able to test it on the scene though.
Okay. But was there anything about it that made you think that it could be methamphetamine?
Yes, they were both individually packaged, so they were both in baggies, and were both a crystallized substance.
Okay, and you'd seen this kind of thing before?
Yes.
Okay. What else did you find?
As I continued my search, I located a black box that was sort of magnetized underneath the driver's seat. And when I opened that up, I located more possible methamphetamine. And then through the continuation of my search, I located another crystallized substance in the center console of the car, as well as about 30 or so small individual baggies and a scale.
And a scale.
Yes.
Your man approach.
Yeah.
I'm showing you what has been marked as people's proposed exhibits 1 through 5. Do you recognize those photos?
I do.
Did you take those photos?
I did.
Are those items that were recovered from, go ahead and look through all 5 of those photos. Are those photos of items recovered from Mr. Joel Dersman's vehicle?
Yes.
I think you already said that you took those photos.
I
So
did
is
take
this,
those. Yep.
are these a fair and accurate representation of the items that you found on October 26th?
Yeah.
People move to admit people's proposed exhibits 1 through 5.
Any objection?
I don't have any objection, Your Honor. I think Mr. Nagel has laid foundation. I don't know that there would be any legal objection to them coming in anyway.
So beginning with
People's 1 through 5 is a minute.
thank you, Your Honor. I apologize. I jumped.
No problem.
Beginning with People's Exhibit 1, can you explain to the court what's in that photo?
Yes, People's Exhibit 1 is a photo of a meth pipe.
Where was that found?
That was found in the center console area of the car.
And-
From what I remember.
And why does it jump out to you as a meth pipe as opposed to any other kind of pipe?
Yeah, so it's a glass pipe that has that has burn marks on the bottom of it. I've made many arrests before and have many people identify these as meth pipes, so my experience is what people use in the meth pipe.
Thank you, officer. Moving on to People's Exhibit number 2, can you tell the court what that's a photo of?
People's Exhibit 2 is a baggie that is full of other baggies.
Okay. And why is that relevant to you in this investigation?
So it's relevant to me in this investigation because typically people aren't carrying around lots of small individual baggies. That mixed with a large amount of narcotics leads me to believe that this was part of a drug dealing situation.
Okay.
I suppose.
Moving on to People's Exhibit 3, what is that a photo of?
This is a photo of all of the methamphetamine that was seized on scene during the traffic stop.
And it looks like there's multiple bags
Yes.
on that, and I think this photo is of this substance on a scale, correct?
Yes,
And why are these on together on the scale like the way that they are in this picture?
they are put together on the scale because these are the baggies that tested positive for methamphetamine. So I wanted to get an accurate representation of how much it weighed the methamphetamine in total.
And these are individually bagged, correct?
Yes.
And is it weighed like this also because they were together in a same bag?
So each and every one of these were, to my understanding, were packaged as they were seen in this. So we didn't, my understanding, we didn't take any of them out. We
Okay.
found them like this.
Do you remember where you found that?
So 2 of them I found right at the floorboard by the feet of the driver, or where the feet of the driver would have been at. And then the other 3 were located inside the small black box that was underneath the driver's seat.
Okay, thank you. Moving on to People's Proposed Exhibits number 4 now. Can you explain to the court what that is?
Yes, this is the crystallized substance that I located in the center console area.
And you may not have been the officer to do so, but were you able to get an identification what that substance was?
Yes, so I was present and taking photos of all of the TrueNarc scans, and I'm trained on how to operate TrueNarcs. And when we scanned this item, it did not come back as a narcotic, it came back as some sort of fancy term that I don't remember, but to my understanding, this is, you know, not an illegal narcotic, but possibly a cutting agent.
Okay, and then people's exhibit number 5, what is that a photo of?
People's exhibit 5 is a photo of all of the evidence put together in one photo.
Okay, and is that black box with the magnetic attachment in there as well?
Yes, the black box, the scale, a couple of straws, the baggie, and both of the bags. So the methamphetamine and the cutting agent are here as well.
And I don't remember if you said so, but the scale was also found inside the vehicle?
Yes, yep.
Where in the vehicle was the scale found?
It was found in the center console.
Thank you. Your Honor, publish the photos for the court?
Yes, thank you.
Did you ask the defendant if he knew about the narcotics in the car?
I did not have any discussions with him about it.
Okay. Was there anything else of evidentiary value found in the vehicle?
Not from what I recall.
Okay. Were the substances, I think you alluded to this, but were the substances TrueNarcs to confirm their identities?
Yes.
Were you the officer that did that?
Yes, I was one of the officers that did that.
Did you actually run the TrueNarc scan?
I wasn't operating the machine, but I was present while it was being operated and took photographs of the scans themselves.
Okay. Did you say there was a passenger in the vehicle?
There was.
Did you speak to the defendant about that passenger?
I did, yes.
Did the defendant say whether or not he knew the passenger?
The defendant said that the passenger was a friend and that they were on his way to a concert.
Okay, thank you, officer. No further questions at this time.
Cross-examination.
Thank you. Good afternoon, sir.
Hello.
I just have some questions about you. I want to start first with the basis for the stop. You indicated that so first of all, you're driving a fully marked patrol car, is that right?
Yes, sir.
And I think, you correct me if I'm wrong here, I think there's 2 officers in the vehicle, right?
It was just there.
Okay. Was Officer Fox, was he in a different vehicle?
Yes.
All right. When you first encounter the vehicle that you ended up stopping, was it facing head on? Were you behind it? Was it crossing at a side street?
Yes, it was facing head on. So I was driving northbound on Regent, stopped at the stop sign at Kalamazoo, and they were going southbound on Regent, stop on the other side of Kalamazoo.
Okay. And then also, ultimately, at some point, did you pass that vehicle?
Yeah, that car passed me.
Okay.
As I was stopped at the stop.
And when is it that you saw the tint in the windows?
It was as it was passing me. That's what I believe I saw.
Okay. Now it's roughly 1:30 in the morning at this point. Is that right?
That's fair.
Fair.
This is late at night. It's dark out.
Yeah, fair enough. It's nighttime and it's dark, right?
Yep.
And your testimony is that you were still, despite it being dark out and despite passing for just a brief second, you were able to see that window was tinted.
Yes.
All right. At any point during the traffic stop, did you check the tint on the windows?
No, I did not.
At any point, did you give him did you give anyone a citation for tinted windows?
I don't recall if I issued any citation.
You said the other basis for the traffic stop was that one of the lights appeared to have a high beam on. Is that right?
Correct.
Is the high beam in and of itself a traffic violation?
So having it on while going head on with another vehicle that close, yeah. But
Okay.
in and of itself, no, I mean, people can have their high beams on, but there's certain rules that go along with it.
Got it. Did you ever check, for example, the high beams to see because you said one of them was on and one of them was not, is that right?
Yes.
Is that unusual for a vehicle?
That is typically unusual, yes.
All right. Did you personally check those high beams?
No, I did not.
Did you issue him a citation for the high beams?
I did not.
Do you recall, I think you said on direct exam, you couldn't recall who the vehicle was registered to, is that right?
That is correct.
Is it fair to say it wasn't registered to Mr. Joel Daresma?
I don't recall.
All right.
I don't know.
And the vehicle didn't have, I think you said the vehicle didn't have insurance on it, is that right?
Yes.
Now you indicated, when Mr. Nagel was asking you questions, you indicated that Mr. Joel Daresma did not have a valid driver's license, right?
Correct.
He also didn't have any warrants, right?
Correct.
So he would have otherwise been free to go because of these were, at best, these would have been civil infractions at that point. Is that right?
With the driving while revoked, I mean, it is a misdemeanor, but I mean, I didn't have any specific intentions at that moment to take him for that charge.
Got it. And to be clear, you didn't issue a driving while license revoked.
I don't recall. But.
The other individual who was he detained at some point?
He yes, I mean he's had him step out of the car.
Okay.
He identified himself, but yeah.
Okay. And he was ultimately released from the scene. Is that right?
Correct.
All right. Okay. Now, Mr. Nagel showed you some photographs, right?
Correct.
So there was an amount of meth that was found in this car. Fair to say?
Correct.
Yeah. And then there was, you said there was a pipe in the car.
Correct.
And the pipe would be indicative of use. Is that right? That an individual would use a pipe to use methamphetamine.
That's one of the ways of using methamphetamine.
Sure. And you indicated that there was some straws in the vehicle. I think I'm sorry. I think you said, may I approach with those exhibits, Judge? I may have misquoted you, and I don't mean to put words in your mouth. I'm showing. Is it 5? Yeah, people's 5. Now you said there was something. I think you said something about straws. Is that right?
Yeah, I identified this photo and said that there was the straws.
Okay, so you're saying that with regards to straws, you're pointing to it's a plastic bag. It's got like an orange straw, I guess, and a neon yellow straw.
Yep.
Fair to say?
That's fair and accurate. Yep.
All right. What are the straws for?
The straws were taken because there was a white substance that was on them. Not enough for us to physically test or anything, but we just grabbed it for evidentiary value. Okay.
Is in your experience as a police officer, is one of the ways that people consume meth is through snorting it?
That is a way of using it. Yes.
All right. And like cocaine, a straw might be used to snort methamphetamine. Is that fair to say?
That is fair.
Got it. All right, may I approach the witness again, Your Honor?
Yeah.
I think I'm done with these. I can hand them back to the court.
Thank you.
Thank you, Judge. And you indicated that there was a scale in the car, right?
Correct.
The scale in some circumstances could be indicative of the idea that a person was weighing narcotics, right?
Yes.
That's one logical conclusion.
That's one way that someone could use a scale with narcotics.
Fair enough. What we don't know is whether the scale in this particular instance would be used for the weighing for sale or the weighing for purchase. Is that fair to say?
I suppose. Yeah.
Did you find any large amounts of cash in the vehicle?
I did not locate any large amounts of cash.
Thank you, Your Honor. I have no further questions.
Thank you. Maybe you're right.
I had something, but I don't think, I think no redirect.
You didn't find any large amounts of cash? You didn't find any cash or just not large amounts?
I don't recall. I don't remember there being any large amounts of cash. There could have been some, but I don't recall it being of a.
If there was, would there have been a photo of it?
If there was anything that we believe that there would have been a fair amount or something that looked like it could have been used for the sales, and we would have.
Okay, sounds good, thank you. Any questions based on that?
Not based on that, thank you.
Any questions based on that question?
I guess just one or two very briefly. Officer, if there had been cash in a large amount, that would be indicative of a person potentially one factor that would be considered in the sale of narcotics. Is that fair to say?
That is one factor, yes.
Right. And because you're logging all the evidence with regards to this traffic stop, you likely would have also logged the fact that there was a large amount of cash, right?
Correct. If I located a large amount of cash, I would have logged it.
And as far as you know, as far as you can recall, there was never any photographs of cash taken. Is that right?
To my understanding, yes.
All right. And you don't recall personally now as we sit here seeing or recovering any large amounts of cash?
I don't recall that. No.
Thank you. I have no further questions.
The people would call Officer Mark Fox here.
Thank you.
I guess I have an issue here because I thought he was just going to get the witness, and sounds like we're having discussions about testimony.
We should probably go in the hallway and find out what's going on. Find out what's going on. Solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
I do.
You can be seated. First and last name, spell both, please.
Mark, M-A-R-C, Fox, F-O-X.
You can proceed, counsel.
Thank you, Your Honor. Officer Fox, can you tell the court with whom you are currently employed?
Lansing Police Department.
How long have you been employed with Lansing Police Department?
About 2 years.
2 years. What are your current duties with Lansing Police Department?
I'm a patrol officer on night shift.
And what kind of things do you do as a patrol officer on that shift?
Run traffic. I take calls for service, make arrests, stuff like that.
Do you have any special training when it comes to narcotics investigations?
Nothing outside of the training I've received at the police department.
Are you trained in the use of TrueNarc?
I am trained in the use of TrueNarc.
What is a TrueNarc?
TrueNarc is a laser device that emits a laser into a suspected narcotic and can read that narcotic and gives me back an output of whether a narcotic is cocaine based, methamphetamine based, or heroin.
And as a user, are you required to be trained on how to use that device?
Yes.
And have you been trained to use that device?
I have been trained to use that device.
Right. Do you get like a certificate or anything?
There's a PDF, and then you have on-job training with an FTO officer.
Okay. And you've completed that?
Yes, sir.
Okay. Were you working in this capacity on October 26th, 2024?
I was.
And did you assist Officer Damon Pulver in a narcotics investigation?
I assisted Officer Biggie, yes.
Okay. Can you tell the court what you remember about that investigation?
I was traveling eastbound down Kalamazoo, and I saw Officer Pulver flip on a car, and I backed him up on a traffic stop off of Regent Street. Do you want me to go into detail about the stop?
No, what did you observe when you got to the stop?
When I got to the stop, I observed a red SUV with dark tinted windows stopped in a driveway with 514 Regent. Officer Pulver's lights were already on. I parked behind him and approached from the passenger side. It was occupied ×2, and I had a conversation with the passenger in the passenger seat.
Okay. While you were talking to the passenger, do you recall what Officer Pulver was doing?
Officer Pulver was talking with the driver, and while I was having the conversation, he was pulling the driver out of the vehicle and taking him back to the front of his vehicle behind, it was just behind the accused vehicle.
Do you remember a time when the vehicle had to be towed?
I do remember a time the vehicle had to be towed. We had run all occupants out of the vehicle on lien. No one had a driver's license, and the vehicle did not have insurance on it, and we conducted an inventory search.
And we've already heard testimony about what was recovered in that inventory search. Did you assist Officer Pulver in any way during that search? I
searched the passenger area of the vehicle. He searched the driver area of the vehicle.
Did you find anything in the passenger side of the vehicle?
I found a methamphetamine pipe approximately 12 inches long.
Okay. And that was, you said you located on the passenger side?
It was on the passenger side of the vehicle.
Did you find anything else in the vehicle?
In the center console, I found a large baggie of what I believe to be narcotics at that point in time, and I seized that along with the other suspected narcotics that Officer Pulver discovered inside the vehicle.
During this investigation, did you pull out and use the TrueNarc scanner?
I did, and in our evidence room on the 4th floor, I assisted Officer Pulver through the entire process of TrueNarcing, bagging, and inputting all the information for evidence.
And do you recall what you were able to identify the substances through the TrueNarc?
Yeah, 16.5 ounces of the substance came back as methamphetamine base, and the other came back as a different substance that was non-narcotic. I don't recall the name of it. Okay. Methyl something or another.
Do you know what that substance is used for?
I don't know what that substance is used for. However, I can say that while we were TrueNarcing the suspected methamphetamine in the smaller baggies, I could see that substance inside the bag, and it definitely looked different from the methamphetamine. So I don't know exactly what it's used for, but I did see a large bag of it, and then I could see it in the smaller baggies.
I just want to be clear what you're saying. So was it mixed in with the methamphetamine?
It was mixed in with it, correct.
Okay,
correct.
thank
So
you.
inside the smaller bags, I could see components of the larger baggie that came back as a different substance inside the smaller packaged bags of methamphetamine.
Okay, thank you, sir. Do you have any conversation with the defendant in this case?
I did. I read him his advice of rights. I asked him what we found in the vehicle. He said he didn't know and stated that he did not wish to speak with me further.
Thank you, officer. I think I'm no further questions at this time.
Thank you.
Thank you. Judge, may I approach and just grab those exhibits?
Yeah,
Thank you. Officer, you said on direct examination that you found approximately 16.5 ounces of methamphetamine. Is that right?
I believe so. It's in the report.
Okay. Well, you actually meant to say 16.5 grams.
Yes, correct.
Right?
Yes.
And so you would agree with me the grams is considerably smaller.
Yes.
You performed a TrueNarc, right?
Correct.
Did you personally, and I don't want you to speculate, did you personally have interaction with my client other than reading him his Miranda rights?
he got him out of the vehicle. Officer Pulver pulled him out of the vehicle. I aided in handcuffing him. I walked him, aided in handcuffing him and was standing by while Officer Pulver searched him. And I walked him back to my patrol vehicle and put him in my patrol vehicle. And then I read him his advice of rights.
Okay. Once you Miranda, I guess to be clear, once you Mirandized him, he didn't make a statement, right? He didn't make a confession about anything.
He said that he didn't know and didn't wish to speak further.
Got it. And just to be clear, when you were talking about the 16.5 grams, that 16.5 grams includes both what was true narc to be methamphetamine and the cutting agent combined.
Negative.
Okay, so the cutting agent is in a different.
It's different. In the report, you'll see it's at, I think it's 25 grams of that cutting agent.
Okay.
I discovered that in the center console.
Okay.
And then when we were true narking it, obviously in the evidence room, we have better lighting to see. While there's true narking it, I have to hold the device against the package and I have to look very clearly that it has good purchase on the clear packaging. I could see that there was some of what appeared to be the cutting agent mixed in with the small baggies. There was a larger chunk of methamphetamine there as well. I think it was the biggest one was maybe nine grams.
Okay, so I think I understand. I just want to clarify this. You're saying that the bag that's 25 grams is the cutting agent.
Correct.
And then there are other amounts that total to a 16.5 grams, right?
Correct.
And you're saying that within that 16.5 grams, there is cutting agent within that.
I believe that's what I saw.
I got it. All right. And so it's not. Well, let me ask you this. Is the true narc able to tell you, or were you able to determine in any way what percentage of the 16.5 grams, what percentage is methamphetamine and what percentage is the cutting?
It does not give me a percentage. It tells me whether or not it's positive for methamphetamine or clear.
Got it. Okay. So we're not exactly sure, and I'm not asking you to speculate, to be clear. We're not exactly sure how much of that is meth and how much of that is the cutting agent. We just know that there's some methamphetamine within that 16.5 grams.
There is methamphetamine within that 16.5 grams, yes.
Right. Okay. Thank you, Your Honor. I have no further questions, and I can return the exhibits.
Any redirect?
None, Your Honor. The people have no further witnesses.
Officer, maybe excuse. As the defense following witnesses today.
No, Your Honor. Thank you.
Proceed to argument.
Thank you, Your Honor. The people would be asking that this case be bound over on both counts 1 and 2. Based on the testimony and the photographic evidence submitted to the court, referring to the criminal jury instructions 12.3, unlawful possession of a controlled substance with intent to deliver. The people have the burden of showing first that the defendant possessed a controlled substance. In this case, True Narc scan confirmed the presence of the substance of methamphetamine. There was a mixture of methamphetamine weighing in the amount of 16.5 grams in total, as the testimony established. That was individual bag. Second, according to the jury instructions, the people should show that the defendant knew that he possessed a controlled substance. In this case, the testimony was that the defendant was in the driver's seat. The controlled substances were located underneath the driver's seat and in the center console. When it was discovered that the defendant did not have a valid license and was unable to drive away, and that the passenger was likewise unable to drive away, there was no request to call anybody else to take possession of the vehicle. Therefore, a reasonable inference is that the vehicle belonged to the defendant or was in the defendant's control. And given the location of the drugs in the vehicle, how they are located, there's a reasonable inference that the defendant knew that he possessed these controlled substances in his vehicle. Third, the defendant intended to deliver the controlled substance to someone else. In this case, we have to go by circumstantial evidence based on what was presented today. The circumstantial evidence presented here, however, indicates that this is a very organized individual with respect to the substances inside the vehicle. There were 16.5 grams individually packaged in a manner that looks like, in a manner that according to the officers, Officer Pulver's experience, looks as if it's prepared to be distributed to customers. There was a methamphetamine pipe located in the vehicle. Notably, however, it was found on the passenger side of the vehicle, not on the driver's side. So we don't know. It is true that the pipe can be consistent with somebody using the pipe, but we don't know if that pipe belongs to the driver or the passenger. But either way, the items in the vehicle do appear to be set up so that the driver can distribute narcotics to other people through the individualized packaging, along with another substance that came back negative for methamphetamine, however, did look to be present in the other bags, given that a larger quantity was also in the possession of the defendant, and some of that substance was mixed in with the bags. There is a reasonable inference that it's the defendant who is controlling what is mixed in the individualized bags containing methamphetamine. Therefore, on that element, circumstantial evidence, I believe in this case, for the purposes of today's examination, raises a reasonable inference that the defendant intended to control that substance and deliver it to other people. And then fourth, that the control of the substance the defendant intended to deliver was a mixture that, in this case, 16.5 grams of methamphetamine that was recovered in the vehicle. Count 2 is maintaining a drug house. In this case, the defendant knowingly kept or maintained a vehicle. Second, that this vehicle was used for illegally keeping controlled substances. In this case, there was that black box that contained some of the items recovered that were connected to distributing narcotics, including the weight scale in the center console. It does appear that this vehicle was set up in a manner intended to be used for the purpose of keeping controlled substances and selling or distributing these illegal substances. And then third, that the defendant knew that the vehicle was frequented or used for such illegal purposes. And again, the way the vehicle is set up in a very well organized manner shows that there was some intent behind organizing this vehicle for those purposes. One more point, I lost my train of thought. I apologize, Your Honor. I had one more point. I think based on the evidence and testimony presented today, I do believe that there is a reasonable inference to support all of the elements on both counts 1 and 2. And for those reasons, Your Honor, we would ask that this be found over as charged.
Thank you, Mr. Palmer.
Thank you. Your Honor, I'm asking if the matter be dismissed for lack of probable cause. I'll make my argument as count 1 first. First of all, Mr. Nagel, to be clear, Mr. Nagel properly cited the elements of count 1. I'm not disputing that. But in particular, my issues are with the second and third elements. That is that the defendant knew that he possessed a controlled substance, and third, that the defendant intended to deliver the controlled substance to someone else. First of all, with regards to knew that he possessed a controlled substance, I recognize that there was testimony that he was the driver of the vehicle. But Mr. Joldersma made no statement. He never admitted that he knew the narcotics were there. He never admitted that he was in possession of the narcotics. And we never even heard testimony as to who the vehicle belonged to. We don't know why Mr. Joldersma was in possession of the vehicle that day. It may have belonged to the passenger, the vehicle that is. It may have belonged to someone else. It may have belonged to any. We never heard testimony that in any way tied the vehicle to Mr. Joldersma other than the fact that he was driving it at the time. Now, I understand, that's why I'm not addressing the first one, that there is constructive possession. I understand that, and that's why I'm not addressing that. But obviously the legislature made it clear that not only did the person have to possess it, but he had to know that he possessed it. And I don't know that there's any evidence, because we don't know who the vehicle belonged to, and because Mr. Joldersma never made no statement, I don't know there's any evidence to suggest that he knew that he possessed it. Second of all, the second half of that argument is that with regards to the third element, that the defendant intended to deliver the controlled substance to someone else. I don't know that we have enough evidence there to suggest that there was some sort of intent to deliver. We heard evidence that there was a scale found in the vehicle that we don't know who it belongs to. We heard evidence that there was baggies found in the vehicle that we don't know who it belongs to. We also heard evidence that there was no cash found whatsoever. There's no testimony about any cash, which would be consistent. Officer Pulver testified that it would be consistent with the person who is selling or dealing narcotics. And then we also heard about two different methods of use of narcotics, that is the pipe and then the straws, both of which Officer Pulver testified are commonly found for people who use narcotics. And further, Officer Pulver admitted that the scale be used for weighing of selling narcotics? Yes. He also admitted that the scale could be used for the weighing of narcotics that were being purchased. And so I don't know that there's any testimony that specifically says or shows that Mr. Joldersma, even if we get to the point where he possessed and knew he possessed, I don't know that there's any testimony to support the element that he intended to deliver it to someone else, as opposed to just being a simple possession of methamphetamine. We also heard this testimony about how there's 16.5 grams. At first they said ounces, but then they admitted it was grams. And we heard this testimony about how there's 16.5 grams of methamphetamine, but then we heard testimony that, well, it's not all methamphetamine, it's cut with some other agent. And we don't know how much of it is methamphetamine. We don't know how much of it is the other agent, which, to be clear, Officer Pulver said the other agent was not something that was illegal to possess. So we don't know, so we can't even really fully go on this idea of weight. And we didn't hear any testimony suggest that 16.5 grams is a lot or a little or anything. We just heard that it was 16.5 grams. 16.5 grams seems like a small amount if you're talking about, I don't know, M&Ms or something, right? Like we don't know, that's not placed into context is my point. I know the court's laughing, but I didn't mean that to be funny, but
I understand.
But that's not placed into context in any way. And so I'm saying that the prosecution has not met its burden with regards to count one, the possession with intent to deliver. I would ask that that count be dismissed outright. If the court doesn't agree with that, then I would ask that at the very least, it only be bound over on a possession charge as opposed to a possession with intent to deliver. I'm asking that it be dismissed outright because there's nothing to suggest that Mr. Joldersma knew that he was in possession of meth. But even if the court gets to that section, I would suggest that it should be possession only. The same argument, I don't know that I need to spell it out, but I'm applying the same argument to the maintaining a drug house count. It essentially has very similar, I can pull it up here, Judge, but it essentially has, again, I don't dispute Mr.
I have the jury instruction.
Okay.
The defendant knew that the vehicle was frequent for the use of illegal purposes, and that the defendant knowingly kept or maintained.
Right.
I get it.
Right. So the same argument applies, right? That there's nothing to suggest that Mr. Joldersma knew or should have known that he was in possession of the meth, because there was nothing to establish that it's his car, that in any way he knew that the methamphetamine was there. So I'm asking that the matter be dismissed outright. Thank you.
Free argument.
no re-argument, but I did remember the point that I was going to make. Just that with all the items you covered from the vehicle, any one of those things may not in and of itself be indicative of having an intent to distribute, but all of them together in the way they were found in aggregate creates the reasonable inference. That's.
Yeah, but I think there was some, I mean, Mr. Palmer made a lot of arguments about some concerns about tying this to his client. And the officer didn't know who the vehicle was belonged to.
Well, right, so there was, and I did come up with testimony that I think he said he didn't remember, but I think it sounds like they didn't check to see if the vehicle was registered to the defendant. I think that's what it sounds like.
But how do we tie this into the element that the defendant knew this was there?
So the way we get there is that since the vehicle had to be towed, if the vehicle did not belong to the defendant could have disclosed that the owner of the vehicle could come and pick it up, and they could just leave the vehicle where it was or call the owner of the vehicle to come and retrieve it. But because that wasn't offered, the vehicle had to be towed, there's a reasonable inference that the vehicle belonged to the defendant.
Because the defendant didn't say we can call the, but was that testimony that was provided that they gave him that option?
Just the totality of the circumstances, that he was in control of the vehicle, he was in the driver's seat, the narcotics and were located underneath the driver's seat. There was a scale, there was bags inside the center console. There was a pipe that is consistent with consuming.
I get all of those things, but my concern now is the sloppy investigation job. Why do they not know who this vehicle is registered to, and why don't they know when they come to court to testify about it? That's my concern. Was this vehicle registered to him? That's important information. You're saying that he's in charge of maintaining a drug house out of this vehicle. Well, who was the vehicle belonging to? Because what if he just borrowed his cousin's vehicle? Was he supposed to look under the seat for drugs before he drove off to drive to the store real quick, or wherever he allegedly was going? Was he supposed to look into the center console for a scale and baggies before he drove off? And so if it's determined that actually this was his vehicle, well, that right there, that we don't need no more. That's enough. But now I don't even know whose vehicle it is, and well, we don't know. Well, if they don't know, then we don't know. And so I'm supposed to find more than mere suspicion that this was his vehicle now, or that he had knowledge that these things were under the seat. It'd be different if it was sitting in the passenger seat where he can see.
The testimony did show that the methamphetamine pipe was found on the passenger side.
I get the pipe, but a methamphetamine pipe sitting in the passenger seat does not lead to there being all of this extra paraphernalia in other places that are not disclosed readily in plain view.
I see where the court.
Right, and I, without a doubt, based on my experience, would believe if I see all of this in a car, I would believe that this is distribution too. I don't think this is use, not all this. Now, what in the world we need all these baggies for? And I agree to the extent that you made the argument, Mr. Palmer, about there's been no real evidence on the record about what 16 grams really is. I can read to that, but I mean, there's a cutting agent, there's all these baggies. I think there's probable cause to believe, based on the totality of all this evidence here in these exhibits, that likely some distribution is going on. Now, what I am not clear on is whose car this was to make me reasonably believe that he would know that this was in there. Do I believe that he knew that there was a pipe there? Absolutely, if it was in the seat.
I see where the court's coming from on those elements. I would stand by the testimony as it came on the record, as I already indicated. But given these good points, I would ask at the very least, based on the testimony and the location of the meth pipe, that this be bound over if not as currently charged on a possession charge instead.
Okay, today was the date that was scheduled for preliminary examination. The burden is on the prosecution to establish sufficient probable cause that the felonies were committed and probable cause sufficient to charge you, Mr. Joe Jurma, with those felonies. This isn't a trial. They don't have to prove each element beyond a reasonable doubt. They just need more than mere suspicion that these crimes alleged occurred. We had testimony today from two officers. They testified that, well, first we started with Officer Damon Pulver, who testified that on or about October 26, 2024, he effectuated a traffic stop in the area at or near 5, I think he said 17 Regent, City of Lansing, Ingham County, State of Michigan. And that the reason for the stop being heavy tint on the front window and high beams being on. And then after the traffic stop, he later determined there was no insurance, and I think the driver who he identified as Mr. Joe's license was revoked. He testified that the vehicle would be towed, and that as a result, there would be an inventory search of the vehicle. And as a result, there were several items located, 2 baggies of suspected narcotics, which one I believe later was true as methamphetamine, other believed to be a cutting agent. About 30 or so small individual baggies, a scale, crystallized substance under the seat or console. Let's see. There was a box with a black magnetic equipment, some straws, and a glass pipe located in the passenger seat of the vehicle. Officers were questioned about, I think Officer Fox testified about his TrueNarc training and TrueNarc testing the baggies or the substance that was later determined to be positive for the presence of methamphetamine. Officers were questioned about whether or not the vehicle was registered to this defendant, to which they, specifically Officer Pulver, stated he could not recall. And I don't know that there must not have been any information that could refresh his recollection, because it wasn't offered. So nonetheless, we've gone through the elements of the charges, first being the unlawful delivery of controlled substance, and that is that the defendant delivered a controlled substance. Delivery means the defendant transferred or attempted to transfer the substance to another person, knowing that it was a controlled substance and intended to transfer it to that person. First, the defendant must have intended to deliver the substance to someone. Second, the defendant must have taken some action toward delivering the substance, but failed to complete the delivery. Second, that the defendant knew that he delivered a controlled substance. And third, that the controlled substance that the defendant delivered was a mixture, in this case, it would be methamphetamine, weighing 16.5 grams. Let's see. Then the other charges, maintaining a drug house. As to the first count and the defense's position about whether or not the inability to identify the owner of the vehicle is enough to cause there to be a sufficient lack of evidence. The court asked some questions to the prosecution, but the court has some questions also as it relates to if I borrow someone's car, if I'm a drug dealer, I distribute, or I have this amount of product in my vehicle. It's just some costly product on the streets. Am I gonna just give my car to somebody to take it real quick without getting my stuff out of it? Not likely, not likely. I think those are questions, both the question there and the questions that I asked Mr. Nagel as it relates to the ownership of the vehicle and the knowledge of this stuff that's being located under the seat, in the center console, in the front seat. Those are questions for a jury of fact. I believe based on the totality of the testimony that there is sufficient probable cause as to count one, a delivery of a controlled substance. And so count one will be bound over to the circuit court. Count two, that being controlled substance maintaining a drug house. Again, the issue or question about the defendant knowing that this was a vehicle that was frequented for the use of illegal purposes. I think the totality of the circumstances would speak to knowledge, because again, whether it was his car or someone else who entrusted the car to him, we know we have constructive possession here, but also if I distributed drugs or if I even used drugs and I was keeping them in my vehicle, I would not give my vehicle to someone else with my product in it. Wouldn't do it. I don't want him to take it and use it for himself or sell it, or maybe don't want him to find out. So for those reasons, I believe that there's also sufficient basis as to count two, that the defendant did. There's a probable likelihood that he did know that the vehicle was being used for this purpose and that the other elements are established by a probable cause standard as well. So count two will also be bound over as charged. The bind over date. No, it's 24th. The bind over date is going to be the 5th of May, not May, the 5th of February. That's the date that the circuit court is going to get the file from the district court. That's not a date that you, Mr. Joe Dozman, need to appear in circuit court, okay?
Yes, Your Honor.
February 2025. Your next court date is going to be a pre-trial in circuit court. Your attorney will be made aware of that date, so you'll stay in communication with your attorney.
Yes, Your Honor.
Bond will continue as said at 5,000, 10%, and I believe it was ordered for your analysis testing 2 times per month. And you seem to regain your connection with pretrial services. That will also continue. Any additional matters for the record?
Nothing, John. Thank you.
Thank you. You're all set.
Yeah. I'll call you. You can call me next week. All right. Excuse me. Yep.
Need a note, you can still interested. After this, the circuit court.
Yeah. I don't know.
Let's see.